The Court of Appeals is now in session.
Good morning, and welcome to the Utah Court of Appeals over the internet. We are glad to have you with us this morning. The first thing I want you to do is state your appearances for the record, and I'll call the case for the record. We're here in the case of Minor versus Minor. The case number is 2020-0098. Who's here on behalf of Lisa Minor?
That would be me, Adam Caldwell.
Good morning, Mr. Caldwell. We're glad you're here. And on behalf of John Minor?
Good morning, Your Honor. Julie Nelson on behalf of Appellant John Minor.
Good morning, Ms. Nelson. I'm guessing both of you have probably already been with us at least once before since we've gone online. Is that right? Am I right about that assumption, or are either of you new to the process of Court of Appeals virtual arguments?
I've been here.
Yeah, it'll be my first on Court of Appeals, but several trials via WebEx. Okay,
well, just a couple of pointers. Keep your view on grid view so you can see us all at once. The clock, as you can see, is appearing on the screen in the box labeled Lisa Collins, and that'll count down as you're used to. It looks like 13 minutes appearing now. Does that mean that 2 minutes have been reserved for rebuttal?
Yes, Your Honor.
Okay, good. And the one thing that we need to worry about is talking over each other. Oh, I disappeared there for a second.
But that's my opportunity to observe that you are not a cat.
Yes, none of us are cats, at least right now. Hopefully none of us will turn into cats during the course of this argument.
Maybe the Cheshire cat, though.
What's that?
Maybe the Cheshire cat.
Yeah, maybe.
So, Judge Harris, you do keep coming in and out. It's a little odd.
I am going to turn my background off, and you're just going to not get to see the nice little courtroom. But maybe I'll try that for a second here while I'm giving some instructions. I can remember how to do that. There we go. So the other thing to keep in mind is when one or more of the judges has a question, to avoid talking over each other, we are going to give a couple of cues. We're going to keep ourselves muted for the most part, so you'll see a little red microphone strike through next to our names for the most of the time. If that little red button disappears, that's a clue that one of us wants to jump in, and we'll probably supplement that with a visual cue, a raise of the hand or something, to let you know that we have a question and we'd like to jump in without talking over you. So pay attention to that if you wouldn't mind throughout the course of the argument. When it is your turn to argue, obviously turn your video and your audio on as though you were at the podium. When it's not your turn to argue, we'd ask you to turn both of those things off so that we can concentrate on the other attorney who is at the virtual podium. If there are any technical difficulties during the argument, if I start disappearing like I did a minute ago, or if somebody loses connection or we can't hear, we'll take note of that, stop the clock, and take measures to make sure that you get your full time and your full opportunity to tell us today what you came here to tell us. So, any questions about the procedure before we begin?
No, Your Honor.
Okay, well, we appreciate you both being with us this morning, and we'll turn the time over to Ms. Nelson at this point.
Good morning, Your Honors. Julie Nelson appearing on behalf of Appellant John Minor. And might I say that in case I fail to observe your visual cues, don't hesitate to interrupt me. I realize this case has a lot of nitty-gritty, and in some ways the briefs look like ships passing in the night. But before digging into that, I'd like to start by taking it from the 30,000-foot view. The court's role in a divorce is supposed to provide a family with some kind of structure to help them move forward. In theory, it provides the children with an arrangement that's in their best interests, and it leaves the parents with what this court has called, quote, sufficient parity to allow both parties to be on equal footing financially. Those are the goals. One of those goals was achieved here. The trial court made it clear from the very beginning that it believed that it was in the best interest of the children. And to be clear, there were 3 minor children at the time of trial, and now there are 2 teenage boys. The trial court made clear from the very beginning that at the temporary order stage, that, quote, in a perfect world, equal time makes sense. That's at the record at 202. At that time, the court ordered a parenting schedule pursuant to 35.1, ordered a custody evaluator and a therapist, and, quote, reserved the right to change the parent time arrangement after trial after the custody evaluator has weighed in. Well, during that period, which was most of 2018, the trial was very drawn out. Dad worked only 40 hours a week. At trial, the custody evaluator weighed in, and she testified that things were going very well. She had also spoken with the children's therapist who had agreed. That's at record 1179. The custody evaluator testified that it was the goal for the kids not just to be at Dad's house, but to actually be with their dad. We lay this out in our brief at page 10. The custody evaluator recommended a year of 8-6 parent time working towards 50-50. And the reason she gave for the transition was, quote, to make sure that Dad's work schedule can continue to accommodate the change. That's at 1193. The court accepted her recommendation. It noted that John, quote, has changed his work schedule, 1091, and, quote, John was working less to be available for the minor children, 1089. As a result, the court determined that equal time was the best arrangement. It awarded 8-6 as a transition with a goal of 50-50, which has now been accomplished. But even though that was the plan going forward, the trial court paired this parent time schedule with the financial picture that existed in the past, back before the parents separated, back when Dad was working most of the time and Mom was taking care of the kids and the house most of the time. But it can't be both. Dad can't work those kind of hours and be the kind of father that he and the court want him to be. Dad working that much hurts the kids, which is why the custody evaluator, the therapist, and the judge were happy to see that Dad was working only 40 hours a week and taking his role as a father very seriously and doing it very well. Now, let's be clear. This is not about sabotaging your income to screw your spouse, which Mom kind of suggests. It isn't like he's sitting at home watching TV and eating bonbons. He's a practicing physician. What we're suggesting is that he should only be obligated to work 40 hours a week instead of 60 to 90 so that he can be present to raise his children. The problem comes in at section 78B12-2032, which talks about setting a parent's income. That statute says that each parent can work one 40-hour job. It says income from earned income sources is limited to the equivalent of one full-time 40-hour job. Now, it does say that the court may consider overtime, but it absolutely does not mandate it. And when that overtime conflicts with the best interest of the children, like it does here, and creates a scenario where Dad can't possibly be successful at both of the court's orders, then we have an abuse of discretion. Go ahead.
So you're suggesting that even though the 2 remaining minor children are in their, the final years of being minor children, that their father is going to confine his work to a 40-hour week and never go back to working the number of hours that earned him $1 million a year?
Well, the issue is that the court has arranged a best interest schedule where I think the youngest child is 13. So for at least the next 5 years, Dad is going to have that child half of the time, both of those children half of the time. I think they're 13 and 14. So we're looking at about 5 years here. Now, should that change later? That's when a petition to modify could potentially be relevant. But right now, the problem is that we have one parent time order that says one thing, and it conflicts with his ability to earn. Now, the other side would have you believe that he only ever worked 40 hours a week and that he can earn $1 million if he only works 40 hours a week. That has been their position. They haven't argued that in the future he'll earn more.
But I thought their calculation was that if you take out the 10 or so weeks of vacation that he enjoyed every year, that it averages 40 hours a week.
No, their calculation was based on comparing hours billed with hours worked. They cite to dad's hours billed, and everyone on this call knows that those are different. Now, if you haven't read it already, I strongly encourage you to read our Addendum M, which is Mr. Caldwell's hearing at the temporary order space, where he explains how crazy dad's job was back then when he was earning that kind of money. When you read that, it's pretty easy to see that it's impossible for dad to do that kind of work and also be the kind of father he wants to be. And importantly, it isn't until this brief that they argue that he's only worked 40 hours. Up until this time, mom's position was that dad worked so much, he should have minimum parent time. Mom's testimony is clear throughout trial, throughout the temporary phase, that dad worked 60 to 90 hours. Dad worked 70 to 80 hours. Dad's never home. Yes, Jessica.
But I don't think there's any evidence in the record other than her just kind of testimony that he would work 60 to 90 hours a week, that he consistently did that. Even your exhibit suggests that at most on average, he worked close to 60 hours a week, but never consistently a 90-hour week to earn those wages. Do you think there's evidence in the record beyond just her one statement to that effect that shows that over that period of time, he was consistently working 60 to 90 hours?
I do.
And his testimony suggests that the highest workers at his place of employment, the heaviest workers are usually working 40 to 50 hours a week. He doesn't testify that anyone's working 60 to 90.
Yes, he testified that he was the highest earner in his group for the last 12 years and that he had worked more than that. And both parties testified that he had worked these crazy hours. Again, I encourage you to read Addendum M, where Mr. Caldwell lays out what those hours were like. But I'd also like to emphasize that 78B 12203 doesn't ask about working more than 60. It asks about working more than 40. And everyone agrees that dad was working more than 40 in order to bill what looks like 40. That was the whole purpose of Exhibit 5.
Did John Minor put on evidence for the court that he could rely on to say that I cannot care for my children on a 50-50 schedule if I'm working any more than 40 hours per week?
Well, what happened was that during that year of 2018, he was only working the 40-hour schedule. And so that's where the custody evaluator's position is very important, because the custody evaluator acknowledges that John has cut back, and the trial court acknowledges that John has cut back. Again, at 1089 and 1091, the court says he has changed his work schedule. John was working less to be available to the minor children. And that was the premise of the best interest analysis. Judge Harris.
Yeah, I want to follow up on Judge Pullman's question there. So she's asking, was there evidence that this was necessarily inconsistent? And I had the same question she had, and I'll go back and take another look. But just sort of theoretically, I mean, is it really inconsistent to have two teenagers on a 50-50 basis and not be able to work the kind of hours that he could that he needs to work to make what he was making? I mean, he's got a week without them, so he could work a lot that week. And the next week when he's got them, he could work. It's not like he can't work, and they're going to be in school. They're going to be in tennis lessons. They're teenagers. They don't need their dad all the time. He's going to be able to work a certain amount of time even when he's got the kids. And so when you put all this together, and the fact that he has a nanny and a right of first refusal at his disposal, I guess I want you to tell me exactly, the basis for your argument seems to be that this alimony award and this parent time award are inconsistent. And I guess I wonder if that's actually true. And can you talk to me about that a little bit, sort of facts on the ground?
Yeah, I think that what's happening in 2018, when the custody evaluator is saying, look, dad has cut back his hours and he's really stepping up and he's really doing a great job and he's involved in doing homework and things like that, that shows us that it was premised on him being home more often. And again, the custody evaluator had said, we don't want them to be at dad's house. We want them to be with dad. And mom testified even that the children testified they wanted to be with dad, not with dad's nanny. And, it transitions to an interesting point about mom's income, because the court found it implausible that mom would find surrogate care so that mom could work. Well, we've got this complete imbalance. We're asking dad to work 60 to 90 hours and put the kids with a nanny all the time. And then mom can't work at all and because she can't have a nanny at all. Well, the statute talks about both parents having equal time and both parents working one 40-hour-a-week job. That's the premise of that statute, is that that's what parents can be expected to do going forward. Everybody can work a 40-hour-a-week job and everybody can have parent time. But what we have here is this. We have dad's going to work all the time and he's going to be at the hospital all the time, overnight, stuff like that. And mom's not going to have to work very much at all. Now that just doesn't make sense. And it's so important to recognize that the parent time award was premised on dad being at home with those children. It was not exclusively future looking. It was recognizing that that was what had been happening on the ground for the entire year of 2018. And John testified that those lesser hours also equaled lesser money. That was undisputed at trial. Have I answered your question? The court says in December 2018 that it's going to enter an 8-6 time and we're going to move towards 50-50. And again, the custody evaluator had premised that on making sure that dad's schedule could continue to support that. Now that 50-50 did end up happening, and that is the situation that we have right now. Now I'm quickly running out of time and there are many more issues to address. I know it's nitty gritty and I know it's going to take a lot of time to piece it through and figure out what this person said and what this person said and what actually happened at the trial court. But I just implore you to do that. I lean on our reply brief and I think that we have two different narratives, but if you look at if you track through our record sites and you track through the cases that we rely on, you'll see that our reply brief is telling you the narrative that is consistent with what actually happened at trial, the evidence that was presented and the evidence that was not presented. So, yes.
I'd like to ask a general question about expenses, monthly expenses. You argue, I believe, that there needs to be documentation in addition to testimony to support monthly expenses. Is that your position? And is that true about every monthly expense in every divorce? That someone needs to come to the court not only with a credible declaration and their testimony, but also supporting documentation for each line item?
Well, let me read to you from Dahl versus Dahl. This is paragraph 95 through 97. That's what you'll want to look at. It says, a party seeking alimony bears the burden of demonstrating to the court that the Jones factors support an award of alimony. To satisfy this burden, a party seeking alimony must provide the court with a credible financial declaration and financial documentation to demonstrate that the Jones factors support an award of alimony. In paragraph 97, Dahl cites Whitehead, where the Court of Appeals affirmed a decision to deny a request where the recipient spouse failed to provide evidence of her needs and where her alleged monthly living expenses were unsubstantiated. And this is important because divorce, we're supposed to provide the recipient with a marital standard of living, not lower, but not higher. We can't just simply have people announce what it was that they spent their money on without any kind of support for that.
So do you think Rule 26.1 is inconsistent with what Dahl requires? Because 26.1 says you need to provide documentation except for monthly expenses. And so do you think Rule 26.1 tells parties one thing, but actually Dahl requires something else?
Well, possibly, but that is what Dahl requires. And here we have focused on two categories of expenses. The first one is where there was no evidence, and the other one is where the amount awarded was higher than the evidence.
Yeah, I want to go back to Dahl, and I want to just note that Dahl came to the court after the trial court had refused to award alimony. And, there's a standard review, abuse of discretion kind of issue here. This one's coming to us in the opposite posture where the court determined that alimony was appropriate. And I just wanted to ask you about paragraph 116 of Dahl, which seems to give the court discretion to do sort of what the court did here to sort of fill in some gaps. The court seemed to indicate the court in Dahl could have filled in those gaps if it had wanted to. It just chose not to. It was very mad at the attorney for mom in that case, as we all know from reading Dahl. But the court here chose to fill in some gaps to the extent there were gaps. And paragraph 116 of Dahl seems to indicate that courts have that authority or discretion to do that, even when there's insufficient evidence. And so I guess I'd like your comment on that.
Well, I think paragraph 116 talks about imputation, which is a word that we normally use regarding income. And I would turn the court to Munoz Madrid, where the court did what you're saying, but it wasn't based simply on the recipient say so. There, the recipient had a friend testify, her roommate, I think it was, testify to what their monthly expenses were. And I think it's important that when we're talking about divorce expenses, especially these kind of discretionary expenses like tennis and help out of pocket things where there's simply zero evidence to support it. Let's think about the entertainment. Mom's awarded $625 a month for entertainment. That doesn't include her travel. She has a separate line item for travel. It doesn't include her manicures and pedicures. She has a separate line for that. And yet she's awarded $625, but she can't think of a single example of what she has done with that money. That cannot be the standard. It cannot be the case that a person can just come in and say, you know, I spend $10,000 a month. I can't remember on what, but that's what I spent. That's where we get a very out of whack marital standard of living. So we have to have some kind of evidence that supports these expenses, and that's exactly what Dahl tells us.
Was an objection made at trial that there was no documentary evidence to support these expenses?
Yes, I think it was discussed. It was discussed with her expert, and there was.
But aside from that, I mean, was a specific objection made saying she needs to bring in actual documentation of each of these expenses, even in situations where some of those expenses were relatively consistent with husbands?
Well, I don't know the answer to that exactly, but I would like to point out, especially on the tennis wasn't discussed at trial, so there would not have been an opportunity for an objection to be made. The tennis line item was introduced into the findings, and so was the change on the car payment. That was introduced into the findings. The taxes, that's plain error, right? We calculate taxes based on what the alimony should be. There was absolutely objections made on the horses. So a lot of these things were baked in through the trial, that these things were sketchy. Judge Appleby, did you have a question? Sorry.
I guess one last question too. And so even someone who comes in with their own testimony, what the court views as a credible declaration and expert testimony to back it up, that's still insufficient in your mind on any line item of a monthly expense.
The problem here was that the expert's testimony, they didn't produce that documentation. And when asked, the expert said he hadn't really looked at the documentation. So now we're talking about an expert who's testifying as a fact witness without having looked at the underlying documentation.
And so let me just be clear. You're saying there's no line item that could be a court could sustain if there's not documentation.
I think that we may be looking at, I mean, I can imagine a scenario where a person says they have no rent and the court says, well, that can't be right. But when we are talking about these kind of discretionary expenses or things that were not even brought up at trial, yes, I agree. That is my position.
So I want to just ask about something you just said about the documentation not being produced. It looked like from the briefing that the main documentation relied on to come up with a lot of these expenses was the credit card statements from 2015 and 2016. Are you saying those weren't produced to you?
So the credit card statements were problematic in that they showed things like Costco, $2,000. And at trial, the expert was asked whether he knew what was bought at Costco. Could he break it down? And he said, no, not really. I haven't really looked at that. And then when asked on cross-examination, Lisa couldn't provide any support either. She just said, that's what I spent. I'm a very honest person. I think that we need to be able to have some kind of explanation for what these expenses are, some way of analyzing. Otherwise, there's no way for the payor to challenge them. If the person the recipient can just say, yeah, I spent all that money at Costco, and doesn't have to provide anything, there's no way for the payor to challenge that. I'm blowing over my time. I will turn the time over.
Well, we kept you over time with a number of questions there at the end, Ms. Nelson. So we'll give you your 2 minutes and plus probably some more depending on what comes up. So thank you for the argument, and we look forward to hearing from you again in a few minutes. Mr. Caldwell, it's your turn.
Thank you, Your Honors. I think to kind of take a phrase from Ms. Nelson. As far as the kind of 30,000 foot view, we're dealing with a situation where the court awarded a combined support and alimony award that was about a little bit less than 1/3 of Dr. Minor's total income. I also think it's important to remember in this case, even though we're now into 2021, that the party's decree was entered back on December 31st of 2018, which means per the Tax Cuts and Job Act of 2017, Lisa is responsible for all of the taxes associated with alimony, and it's tax deductible to Mr. Minor. And so when you're looking at a third, that takes into account the taxes as well. As far as the issues go with my client's ability to earn income, there's been a repeated issue that Lisa is essentially shirking in her responsibilities because after being essentially a stay-at-home mom for more than 20 years, she's not immediately, wasn't immediately jumping back into the workforce. There was some criticism. Yes, go ahead.
I just have some questions about her master's degree.
Yes.
Because the blue brief suggested that her master's degree is no good because she didn't complete a thesis. And in my understanding of master's degrees is you don't have a master's degree unless you complete a thesis. But the red brief said that she completed the master's degree but didn't take the test for certification.
Right.
So does she have a master's degree or not? And is it usable or not?
I think that's kind of the same. The same example would be: did you go to law school and did you take the bar exam? So I think they're kind of two different things. That so in an attorney standpoint, yes, she would have gone to law school, but no, she didn't take or pass the bar exam.
So you have a JD, but you're not a licensed lawyer.
Right. I think that would be the same thing.
She did complete a thesis. She just didn't take the test to get licensed, and presumably could.
That's my understanding.
Thank you.
Yeah. So anyway, the point, the issue is that where Ms. Nelson points out that the court didn't reasonably expect my client to get it, to let's say immediately re-enter the workforce after the 20 plus years. I think that's irrelevant because the court nevertheless followed the rules when it came to imputing income to my client, regardless of whether or not she actually got a job. The imputation was still there, and both the rules and law were followed as far as coming up with that imputation. I think the real problem that Dr. Minor has in this situation is that he doesn't like the testimony of his own expert witness. Dr. Minor got a vocational analysis that went through all of the factors. The brief takes criticism of the trial court because the trial court in its ruling mentioned some of the factors, but not all of the factors. But nevertheless, his own expert does go through all of those factors that are found in code and comes up with several suggestions as to what Lisa would reasonably be capable of doing. The imputation that the trial court came up with really isn't that far off from what the vocational analyst was suggesting that Lisa could be doing. In the reply brief, they take issue with that the trial court failed to consider, for example, the fact that she could be an office clerk. Because Lisa, acknowledges that, well, yeah, I guess in theory I could be an office clerk. But in that situation, the expert report mentions that an entry-level office clerk would be, I believe, $18,090 a year. The court imputed Lisa with $1,500 a month, which comes out to be $18,000. So as far as the suggestion of what Lisa should have considered being an office clerk, we're talking about a $90 a year difference, which equates to the expert and the judge being about 4 cents per hour apart once you calculate the weeks, days, and hours. They're really not that far apart. And so I certainly think, given the situation of Lisa not having been in the workforce for 20 years, I think it's reasonable for what the court concluded, especially when it's consistent with Dr. Minor's own expert testimony as to what Lisa would be reasonably capable of making. As to the next issue, as far as Dr. Minor's income, we have testimony as far as we've got the parties, we've got two different accountants that testified, and then we have another anesthesiologist that also testified in trying to determine Dr. Miner's income. If you look solely at the tax returns that were, I believe, the 3 years prior, his average income was $990,000. The trial court reduced that to find that his annual income was $900,000. Yes.
But wasn't that reduction to account for this 8% difference in I think, was it the insurance reimbursement they anticipated, and didn't account for the change in a schedule?
Right, and I think that's a little bit problematic. The trial court did it nonetheless, and obviously we didn't appeal. But yeah, it was an anticipated reduction. It wasn't an actual reduction. It was merely anticipated, and so the court went ahead and gave him that reduction based on the anticipated decrease. As far as yes,
So then it's true though that the court didn't reduce the income from the historical income to account for him working less hours than he had in the past. Is that true?
correct. The court's reduction was not based on Dr. Miner saying, "Oh, I'm working less, I'm taking more vacation." It was based on and by the way, there's going to be a change for how reimbursement works, and we anticipate that it's going to reduce my income that way. That's correct. Ms. Nelson mentions the code as it relates to the 40-hour work week. Obviously, the code specifically states that during the time before the original support order, the parent normally and consistently worked. The parent normally and consistently worked more than 40 hours at the parent's job. The court may consider this extra time as a pattern in calculating the parent's ability to provide the child support as it relates to child support here. As Ms. Nelson testified, Dr. Miner acknowledges that he was the highest earner at his particular job for the prior 12 years. And so when the code specifically gives the court this discretion, and when Mr. Miner himself acknowledges that this is a pattern of 12 years, I think this court would be hard pressed to find that it was then an abuse of the trial court's discretion to find that additional income. I think it will also, although it would make future trials a lot simpler, the code currently doesn't let a potential payor to come in and just tell the court, well, I've done this for the last 12 years, but suddenly now that I'm faced with child support and alimony that I don't want to pay, I'm suddenly going to take all this additional time off, and I'm going to make significantly less. I think that's also kind of that's similarly addressed in I don't know how to pronounce the party's last name. I believe Gerwe, Gerwe. I kind of had to. I like what the trial court found, where the trial court uses the words that in this case the husband comes into trial making a huge amount of money as a colonel in the Air Force, and then all of a sudden is making no money because it's time to pay somebody. And so in this case, yes, sorry, go ahead.
So you don't think there's any credence to his suggestion that he's working less hours to spend time with the children? I mean, there were the custody reports and things introduced at trial to show that he had actually spent more time with the children than he used to. And so he's saying, this is why I'm doing this. It's not just to make less money. It's so I can spend more time with my children. Shouldn't there be some recognition that his hours at work could at least reduce in some way?
I think Judge Harris was more on to as far as the answer with his question, in that I would agree that given the week on, week off, we're dealing with teenagers. We're dealing with Dr. Miner, who throughout the course of the divorce had his own nanny. On top of that, we're dealing with teenage boys that are going to school, have after school activities. And so, yeah, the idea, and I realize, you could debate, how much time he was actually working before, whether that was 60 to 90 hours, or whether, I think in the reply brief, the calculations show working an average of 58 hours a week. I don't think it's that difficult, especially at the time where he was also the scheduler of the hours and scheduler of the shifts, to on a week on, week off situation, take more of a workload the week that he doesn't have the boys, and then to take a smaller, let's say 40-hour work week during the weeks that the boys would rather be in school and their other activities. So I think the problem is Mr. Minor, as part of that, said, well, I'm also going to be taking an additional 6 weeks of vacation, which I think got him up to 3 months a year. And so while it might require some shifting around of when he's working, how many shifts he's working, there's no reason that he would need 3 months entirely off. So essentially sitting around home during the day or the weeks the boys are still in school, tennis, doing other things. The other thing that's indicated in there is that as an anesthesiologist, there are different types of work that can be done, and one of the things that he completely gave up was the OB shifts, essentially saying that he didn't need the money and it's something that he didn't need to be doing. And so certainly maybe some, as with all divorces, there are certainly changes to parties' schedules and how you work, but I don't think there's anything to suggest that Mr. Minor wouldn't be able to do something like that. Yes.
The OB shifts among the least predictable, though?
No, because my understanding of how those worked is an OB shift is you would work a 24-hour cycle, and then so you would be on for that entire day. You certainly couldn't predict how many deliveries you were going to have in that 24-hour shift, but you knew for that 24-hour period, you were going to be the on-call physician where you had to, be X number of minutes away from the hospital. In fact, the record even talks about Dr. Minor on some of his OB shifts taking the children to the hospital, spending the overnight, and having a great time there at the hospital, doing homework, things like that. Yes, Mr. Church.
Ask about a different angle of his income. There's an argument made that the district court did not properly account for business expenses, and I'd like your take on that. It looked like the district court did not include things like licensure fees and malpractice insurance and overhead in Dr. Minor's reasonable business expenses. And I guess at first I don't quite understand why not. Was it because the trial court felt like those weren't reasonable business expenses? That seems wrong. Those do seem like reasonable business expenses for an anesthesiologist. Or was it because there wasn't sufficient evidence presented to the trial court of what those expenses were? Can you help me understand why those were left out? And your argument, I guess, is that we should affirm the trial court on that. Help us understand that.
Yeah, I think the answer is simple. I wouldn't say there was insufficient evidence. I would say there was no evidence presented as far as licensure, things like that. Dr. Minor, my recollection is Dr. Minor produced almost nothing to help the court figure out what business expenses might be. And as far as overhead, my response to that would be Dr. Minor doesn't have overhead. He doesn't have he doesn't have a location. He doesn't have a clinic. He doesn't have staff. He doesn't provide supplies. He literally himself just shows up to the hospital. Everything's there. He does his job. And so from that standpoint, there is very little to no overhead expense. I think, as pointed out in the reply brief, well, there's licensure fees. Yeah, there were licensure fees, but I couldn't tell you what they were because there was no evidence presented to suggest what those might be. So instead, because Dr. Minor essentially refused to provide any evidence as to what his business expenses are, other than, I believe, to say, well, I've got a Costco, I think it was a Costco Visa or something like that he used that was written off as business expenses. And so the attitude was kind of like, well, whatever I put on my credit card is a business expense because I deducted it on my taxes. So that wasn't particularly useful for the trial court. So what we did instead was Lisa brought in another anesthesiologist that worked for that exact same company and had him testify, as to what expenses he might expect to incur. And that's where you got into, a vehicle and a laptop, some whatever the continuing medical education, if that's a thing, whatever the equivalent of a CLE is. And so it was this Dr. Larson that testified as to what his expenses were and what he reasonably felt the other expenses would be for an anesthesiologist working for that particular company. And so simply the answer is, perhaps licensing fees would be a legitimate expense, but there's no evidence in the record to suggest what that might be.
And Dr. Larson didn't testify about what his licensure fees were or what his malpractice insurance premium was? I could be wrong on this, but I think malpractice
might be in there. I can't remember whether it's specifically in there as an example. I think it's in paragraphs is it 18 to 20 of the findings that do acknowledge what expenses he was given, but I just can't remember whether it was something that was provided by the employer or whether it was included. But so I believe the malpractice was included, but the annual license fees, that wasn't included, but it wasn't included simply because Dr. Miner didn't provide it and nobody thought to ask Dr. Larson when he was going through a list of what expenses were included. I see my time's up unless, yes, question.
Doc, I don't think insurance, for example, was provided, but let's just assume.
Might not have been.
If Dr. Miner had testified himself and said, I pay, I don't even know what it would be, $10,000 a year for this insurance, do you think that would have been sufficient if the court had relied on that as evidence of his expenses?
It could be. Certainly, probably the better answer would be to have an invoice statement, check, something like that. But I think certainly it would also be within the court's discretion that if he merely testified as to this is what I pay, and the court found the testimony to be credible and reasonable, then yes, I think that's an expense that the trial court would have discretion over.
Can I ask you about the tenant's expenses? It's $1,000 a month. It's something that was added that the court didn't identify in its findings, right? It was added after the fact. And so I'm just wondering, where Lisa didn't testify as to what that $1,000 would specifically go to, how was that an appropriate expense for the court to identify?
Yeah, so from being this is where being the trial attorney versus the appellate attorney, I think a little bit different, because I'm a little surprised that the tennis expense would be an issue, because from the 4 days of trial, the prior hearings, the parties' lives kind of essentially revolved around tennis as far as the two boys and traveling. And as an example, shortly before separation, but after the divorce had began, Dr. Miner alone spent, I believe it was about $21,000 or $22,000 just for tickets to go watch one tennis event. And so for Lisa to be awarded less than what Dr. Miner would spend on literally watching one tennis event, I think it's a little surprising that he would now take issue with that. And so I think what happened is, even though it appears in the finding, my understanding is we have Lisa testifying to what her expenses are. We have Dr. Miner testifying to what family expenses were as part of the standard of living. But you also have the accountant that did the lifestyle analysis as far as analyzing the parties' bank statements and credit cards to figure out what was being spent. And of course, the problem we have is that everybody is using essentially three different grids to basically break down expenses. In 26.1, the standard full disclosure financial declaration doesn't have a line item for tennis, but instead it has a line item for entertainment. And so and I don't believe George Graff, the accountant specifically, broke out tennis as a separate one, but I think it might have been Dr. Miner himself that had a separate line for tennis. I'm just going off memory there, but nevertheless, whether ultimately those expenses get put under a line item for tennis or whether they could put under a line item for broken up between entertainment and traveling and just general kid needs, I don't think it changes the fact that the money was spent. I think it kind of goes back to for example, the Costco example, where it talks about, well, she put $2,000 on Costco, but she couldn't recall what was spent. Well, I think the answer to that could be a simple solution. Well, the court could have just created a line item for Costco that just simply said $2,000, because that's what the parties had historically spent. And I don't think it would be necessarily fair to attack Lisa for not being able to go back and be able to specifically break that out. So I think the answer is that as to tennis, under her proposed budget and the proposed budget from the lifestyle analysis, those tennis expenses are there. They're just essentially baked into other expenses such as entertainment and travel.
Can I ask one more question?
Yes.
What do we do about the fact it seems like so many of her expenses, at least the ones that start to get higher and that are objectionable, or at least objectionable from the other side, they relate so much to the kids, right? They're expenses that she incurs that don't get put into child support, because child support is relatively defined as to what it covers. Right. But they may be legitimate expenses for her, but aren't they going to phase out relatively quickly when these kids move on. And so I'm just wondering, what do we do in situations like this? Because I think part of the objection feels like this is 20 years. It's a big chunk of money. But where so much of it relates to these kids, I'm just wondering, does that seem like...
Yeah, I think another way the question could be asked would should Lisa be punished for focusing her life around the children? In that you have a certain lifestyle, you have income. There's no question that there's some question, but it's pretty solid as far as what income came in and what was spent. And I think it's just kind of the dynamics of as life as it changes. You're going to shift from different things. For example, I think it's a little unfair, let's say, to Lisa to say, well, you've got $1,000, but it has to be for tennis. Well, what happens if Lisa suddenly becomes interested in curling or dog sled racing or something like that? Does that mean she suddenly loses the money? And so I think it's a function of just kind of the ever changing life and the income during that period. That's what the family chose to do. They chose to go to tennis tournaments and other things like that. And if in the future Lisa wants to do, for example, spend $21,000 going to watch tennis after the fact, I think that goes back to what the standard, consistent with what the standard of living is. Children growing notwithstanding, for right or for wrong, we do have child support that's built in, and Lisa is inevitably going to suffer a decrease in income as child support drops off. No other questions? Thank the court for your time.
All right. Thank you, Mr. Caldwell. We appreciate the argument. We're going to go back to Ms. Nelson for at least 2 minutes and maybe a little more of rebuttal. Ms. Nelson.
Thank you. There's a lot to say. Is there anywhere you'd like me to start? Maybe we could talk about the tennis for a minute. The important thing about the tennis is that John said he would pick it up. John said that the tennis was important to him and he would pay for all of it. And I think that the thought that maybe she'll switch over and do dog sledding and curling is exactly why John said he would pick it up, because this was important to the kids and important to John. This was not Lisa's thing. Lisa's thing was horse riding. We know that. And so John said that he would pick it up. She never brought it up during trial. She didn't put it on her financial declaration. She just decides she's going to take $1,000 for tennis, and now she's going to take $1,000 and maybe use it for dog sledding or curling. Well, that tells us that this was not one of her expenses, and therefore it cannot be included in the item. Now, it's also not true that tennis was part of her entertainment. In the record at 884, she makes clear that her entertainment was not for tennis. So it's not that. In terms of the business income expenses, I would direct you to page 44 of our brief. We've been very clear that there were some expenses that were disputed and we haven't challenged those. The expenses that were undisputed were the ones that were testified to Lisa's forensic accountant and Lisa's brother, and they laid out numbers. So it's not like there was no evidence. Lisa provided the evidence. So at a minimum, the court should have found that as a business deduction. And the court never said, I don't find that malpractice insurance is an important business expense. It just overlooked it. So maybe it just overlooked it and it needs to go back and make a finding, or maybe it rejected it, in which case it still needs to go back and make a finding because, as you said, that seems pretty important. On her income, here I would direct you to page 34 of our brief, where the numbers are more clearly laid out. She testified that she could make more like $16 a month, I think $20,600 a year. She agreed with that. And Mr. Caldwell's argument makes it sound like these are nickels and dimes, but when all these things are added together, this is a lot of money. And as Judge Pullman has pointed out, it is for 20 years. And we are asking John to work for 60 to 90 hours to sustain that lifestyle. I think if we are honest with ourselves, then we can acknowledge that John's long hours probably contributed to the demise of the family. And it seems absurd, perverse, in fact, to require that John, because he had done that, now must continue to work more than the 40 hours recommended by the statute. I turn you to Addendum M again, where Mr. Caldwell says, what my client would further testify to is, though this certainly might be a lot of work, that's after he's detailing the hours. He says it doesn't account for how much time the respondent is actually gone. On that same page, this is 2434, he says, the schedule itself undersells how busy and how frequently gone he is. Now he says, oh, it's no problem. You can reconcile. You can just work a lot during 1 week and then only 40 hours the next week. That's not what he said at the temporary order stage. It cannot be true that the same evidence goes in favor of what Lisa wanted at the temporary order stage and now what Lisa wants here, even though they're completely opposite. I just would say that those hours were an unsustainable standard of living at the time. John testified that they had this house they couldn't afford. They were underwater on it. They had to get out of it. This entire structure does not achieve parity between the parents. Mr. Caldwell talked about the percentage of John's income, but let's say John makes $1 million and he pays 40% of that in taxes. Well, then he's left with $600,000. Now we take off Lisa's $24,500 a month and John gets the rest. But if John starts to bring his hours down to something that resembles like a reasonable work schedule for a doctor, then he makes maybe $600,000, which is what he testified to in 2018. It wasn't forward looking like the pilot. John testified, this is my income now. And at the end of 2018, we introduced his final numbers to show that, in fact, it was like 525 or something. We were still paying 40% of taxes on that. And then if you give Lisa $24,500 a month, John's left with like $60,000. Well, this is not the parity at all that alimony is intended to achieve, nor does it go to the best interests of the kids, which ask for dad to be around, not dad working all the time, which Lisa testified was how it was beforehand. As a result, the court's order is inconsistent, it's impossible, it's inequitable, and it's clearly an abuse of discretion. We would ask you to reverse and remand and order the trial court to reconcile, to acknowledge the parent time going forward and make it reflect John's ability to earn. If there are no further questions, we'll submit on the briefs and it's appropriate to beg you to go through them and track the record sites.
Thank you, Ms. Nelson. We appreciate the argument from you as well, Mr. Caldwell. We appreciate you both being here this morning to help us understand this multifaceted case a little bit better today. And we will take this matter under advisement, as we almost always do, and we'll get you a written decision as soon as we're able to do so. Thank you for your appearances today. The court stands adjourned.
Thank you.